Hello, everyone, and welcome to Thorough Newspaper Analysis, which is brought to you by LawSikho. So, these are the articles that we will be discussing today. The first article is Justice as Relief, which is from the Indian Express. And this talks about the importance of victim compensation being as a part of the criminal justice system or the criminal jurisprudence in any kind of criminal system. So, we'll be discussing the same for the Indian system as well. And the second article is again from the Indian Express, which is titled as Targeting Big Tech in US, EU. So this recently, because we know that some states in the United States have actually lodged a complaint against, as in they filed a complaint against Google. So what was the entire situation and why is it important to understand the role of big techs or the big technological companies is important. And finally, we have the Newsflash column. And if in case you're finding my voice to be a bit too grainy and heavy, please pardon me. I've not been keeping well with my voice, so I hope it's not that big a problem. So if in case you're preparing for judicial services examination, you can definitely have a look at the lot of the courses, which is the judiciary test prep course from LawSikho. The link to this course is available in the description box. You can download free study material as well for your own preparation. We're also excelling into various other courses like for CLAT, All India Bar Exam, SEBI, etc. You can have a look at them too. So this is the multiple choice question. So it is from today's discussion itself. Which of the following sections deals with victim compensation under CRPC, which is the Criminal Procedure Code? So your options are Section 350, Section 355, Section 356, or Section 357. You can write down your answer in the comment section below. This is the descriptive question for the day. Victim compensation is an important aspect of criminal justice. Discuss the various provisions that deal with the same in India. With this, let's start the discussion for the first article, which talks about the victim compensation. So recently, the Delhi High Court in the case Karan versus State NCT of Delhi has secured the right to restitution for victims of crime. Now, as we know that victim compensation is anyway a very important part of any kind of criminal justice system, wherein it is made sure that not only the the offender or the person who has been convicted by the court is given the right punishment, but also on the other side, the person who has suffered the harm. Now, it can be a physical harm or a mental harm or even a harm to his property or any kind of harm that he might have suffered due to the activity of that particular offender. So it is the duty of the court and that is the very right manner in which the justice can be provided to the particular victim. So that is why yet another time in the case of Karan versus State NCT of Delhi, the Delhi High Court has reiterated the importance of restitution for victims of crime. Now, basically, here what we need to understand, we'll also be discussing it further, that Section 357 of the CRPC, which is the Criminal Procedure Code, provides for the right to compensation or victim compensation. But one lacuna that we always see in Section 57 or the language of this section is that there has been no differentiation drawn between restitution and what we call as the compensation. There is no kind of clear distinction or differentiation that has been explained between restitution and compensation. So as we know that restitution and compensation are two different things. Compensation is something that the state must provide, the government has to provide to the victims, and restitution is something which the offender provides because he has done this harm to the victim. So that we'll be discussing later, but all in all, in this case, the right to restitution has been reiterated by the Delhi High Court. Now let's understand what is Section 357 of CRPC and what are the various limitations or constraints attached to this section. The Supreme Court in Ankush Shivaji Gaikwad versus State of Maharashtra in 2013 said, or it held, that lower courts must apply judicial mind and record reasons for passing or not passing orders, and this application should be made mandatory. So in this, we need to understand that in this case, the Supreme Court said that it should be made mandatory for the lower courts to give correct, reasons for, and it should be applying its mind and record its reason for either passing a compensation order towards the victim and or for not passing. So either way, the reasons must be provided by the lower courts. Now, here are a few constraints which are faced by the lower courts. The language of Section 357 allowed orders only for such compensation as may be recovered by civil court. And there is absence of uniform head to grant the compensation, because it is not clear as to who or which authority of the state would be granting the compensation, as it is not provided clearly under the language of section 357. And the uniform mechanism also to calculate the compensation. What we need to understand here is that for every kind of offense, there is a particular kind of harm that is caused to the victim. So the compensation that is paid to the victim is, in most of the cases, as we know, it is almost equal to the harm suffered. Though, as we know, that there are different kinds of compensations as well, like we have exemplary compensations or exemplary damages as well, but they are always an exception. But in the general sense, the compensation should also be in the quantum to the harm suffered by the victim. But what lacuna is there in section 357 is that there is no uniform system, or there is no particular method to calculate as to what amount of compensation should be paid for what kind of harm suffered. So this again creates confusion, and it is again left to the only to the interpretation of the courts, which many a times is left very not used in a proper manner. And then there are also not proper sentencing guidelines in case the compensation is not given, or what in what way the sentence should be taken forward has not been provided. So here you can also understand what restitution means. So it means in restoring act or giving an equivalent for any loss or injury, and it is made by offender or accused or by third party. So it is not done by the state. It is not the state that pays in the restitution. Rather, it is either the offender or it is some other third party, that could be any, like the insurance company. Now, this is the language of section 357. This is the exact Bare Act language. You can definitely go through it and understand as to what are the constraints or limitations that are there in this language. Now, let's understand that what basic provisions or systems, at least that we have available in date, do we have in India. So we have the VIR and the VIS. So VIR is the Victim Impact Report, and VIS is the Victim Impact Statement. Now, a difference has been shown between VIR and the VIS. So if we talk about the Victim Impact Report, so basically the significance of Kannan verdict, so this is a very important case in this regard, lies in the use of VIR to determine the quantum of compensation. So according to this case, it was said that Victim Impact Report is a very essential step that should be taken up by the courts in order to calculate the compensation that should be paid to the victims. So basically what VIR is, that it is loosely based on the concept of victim impact statement, but still it is a bit different, and there are some significant differences in both of these provisions. So it is not directly made by the victim before the court, and it is filed by Delhi State Legal Services after conducting a summary inquiry. So basically it is not the answer, or it is not directly the statements which is given, as you know, even over here it is a statement and this is a report. So obviously there must be some particular authority that must be submitting its report after some kind of inquiry to the court, dependent on which the compensation would be paid. So just like that, it is the Delhi State Legal Services Authority that actually gives this report after a summary inquiry, and based on this report the compensation is paid to the victim. But on the other hand, we have the victim impact statement. Now, as we know that in our terminology that we use for the courts in India, statement is something, or it is the words, or it is the entire report which is taken directly from the victim. So here, it is an instrument of victim participation, wherein complete description of physical injury or any kind of emotional harm or damage or loss to the property is recorded properly. And here, the victim directly addresses the court and comes in terms with the offense. It actually helps to decide quantum of sentence and fine. Now here, the difference is that it is the victim who actually and directly is able to tell the court as to what he is going through, and then it is perhaps easier and more practical for the courts to decide as to what would be the appropriate amount to be paid as compensation. Rather, on the contrary side, in the VIR, which is the Victim Impact Report, it is not directly the victim that tells the court his plight or his suffering. Rather, it is a report. So, in it, many times it is considered that this report is subject to manipulation as well, and also as per the understanding of the team or the entire body which decides or which prepares this report. And this is a more direct and more practical manner to do this. Now, here are a few steps which are needed in this direction. So we should amend section 357 to firstly differentiate between the restitution and compensation, and we should effectively use VIR and VIS both in not just calculation of the restitution, but also sentencing. So the court should adopt them as one of the best practices. So we hope that it was quite now clear, and now you understand the entire procedure that is followed in the Indian context. Now, for the second article, we have regulation of big tech and what is it to do with India as well. So recently, the European Union issued two draft digital services laws that could launch an overarching supervisory apparatus covering tech companies. Now, why at all are we discussing about this article is that in the times of COVID-19, as we know that according to the recent reports, since the time of lockdown, 13% of increased use has been seen in the case of internet. Now, in this regard, the companies or the tech companies that offer us with these opportunities, like we have Google, so these companies actually, or another tech giants also, so these actually have been playing a very important role. And now many a times the states have been noticing that they are trying to create a kind of, a monopoly, in a way we can say, or in a way they are going unregulated, which definitely is not good, because as we know that excess of everything is bad. So of course, internet and the access to internet is important, but definitely there should be some checks and balances on it as well. And that is why the European Union has issued these two draft digital services laws, which would actually be capable of controlling the overarching or over exceeding supervisory apparatus brought by the tech giants. So let's understand that what are the various regulations by the European Union and the United States. So as per the European Union, so here are two laws, Digital Services Act and Digital Markets Act, that could potentially render big tech liable to face multi-billion dollar fines in Europe. So if at all, if they would be doing anything that is arbitrary, or that is something which is not in the public order, or would try to create any kind of monopoly, or would try to make an overreach, so in this regard, huge or hefty fines would also be put up on these companies. And on failure to comply to pay those fines, the companies may be broken up as well. So these are really strict laws, and we hope that they're actually able to curb down this, you know, this ever increasing use of big tech giants, and so that they don't just politicize, or they just don't control the entire market in their own way. And then in the case of United States, the federal government initiated an antitrust cases against Google and Facebook, and large number of US states also, as we know that their states also have their different procedure and mechanism, they collectively launched action on two of these companies. So here, if we talk about the regulatory scrutiny in India, that what has India been doing to regulate these big tech giants in India? So in 2018, CCI fined Google with rupees 136 crore for search bias and such, giving undue space to the flights option in homepage. And then in June 2019, it again said that Google abused its dominant position in domestic smartphone market. And this way we get to know that even in India also, we have been taking these steps to make a complete controlled situation and environment for big tech giants as well, so that all can grow equally and there is not excessive access given to any one particular company or any one particular sector as well. With this, let's see what do we have for news and flash today. India loses Karen arbitration case. So Karen Energy PLC won a major relief of $1.2 billion in retrospective tax on grounds that India's demand on the tax was in breach of the guarantee of fair and equitable treatment. So basically, this was all going on. This relief was actually given by the Permanent Court of Arbitration, Hague. So here also a prelims question can come for you, that where are the headquarters of the PCA, which is the Permanent Court of Arbitration? So it is in Hague. So the latest thing that we need to know is that India has lost this arbitration case. So we're done for the day. We hope it was a good session for you. If in case you wish to download the slides PDF for the day, please join our Telegram group. We share the link for these every day. So you can also visit our official website for any other information. Thank you so much.